The day that DCS took her back was the hardest day I'd ever experienced in my life, knowing where she was going.
When 5-year-old Kinsleigh Welty arrived at an Indianapolis hospital in 2024, medical personnel said she weighed less than she had when she was just 2. She was covered in lice and feces. You could see her bones through her skin, and her hair was falling out. Officials say little Kinsleigh starved to death, locked in a closet inside of a trailer home. And now, as some of her closest relatives who were supposed to love and protect her are facing felony charges, her grandfather wants to make sure to hold DCS accountable for its investigation into Kinsleigh's well-being, or lack thereof. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Now here's the truth. We wouldn't be able to cover a story like this if it wasn't for the incredible support that we get from our sponsor, Morgan & Morgan. I'm talking about America's largest personal injury law firm. I'm talking about a firm with over 1,000 attorneys who have recovered $25 billion for more than 500,000 clients. Think about that. In fact, in the past few months alone, a client in Florida received $12 million when insurance offered just $350,000. Out in Pennsylvania, another client was awarded $26 million. That is 40 times the insurer's offer. Morgan & Morgan, they make it easy to fight for what you deserve. You can even start a claim from your phone. So if you're injured, you can start a claim at forthepeople.com/LC Sidebar. You can click the link below, or you can scan the QR code on screen. The paternal grandfather of an Indiana 5-year-old who died last year has filed a lawsuit against the state's Department of Child Services, claiming inaction by nearly a dozen people allowed his granddaughter to slip through the cracks and ultimately into her grave. We're talking about Kinsleigh Welty. It seems she never had a chance. From the time she was born, her mother was the subject of multiple DCS investigations, including when Kinsleigh was just 1 month old. And according to court records, her mom, Toni McClure, was actually convicted of felony child neglect, but Kinsleigh and her siblings were repeatedly returned to McClure's care. This is according to her grandfather, Brian Welty. And despite multiple people knowing about the conditions that Kinsleigh was living in, that's the allegation, they allegedly didn't stop it and didn't report it. So now McClure, her mother Tammy Halsey, and her live-in boyfriend Ryan Smith, they all face charges, with McClure expected to go on trial next year for murder. And we got our hands on dozens of pages of court documents that lay out the allegations against the 3 defendants, as well as a brand new lawsuit that was filed by Brian Welty that names not only McClure and Smith and Halsey, but also specific DCS caseworkers who allegedly not only dropped the ball, but maybe never had it in the first place. So to help me talk about this, I want to welcome on Indiana trial attorney Andrew Baldwin. Thank you so much for coming back onto the show to talk about this. You know, I hate that we have to talk about these stories that involve alleged abuse against the most vulnerable people in our society, but it is important to know what these defendants allegedly did to Kinsleigh. So to make sense of these charges against the defendants, as well as the allegations made in the grandfather's lawsuit, have you been following the case? What are your initial thoughts on this?
I was in trial last week, and so I did not see anything on the news about anything. We trial lawyers are usually keeping our head down on what we're dealing with. Then you read this, the lawsuit, the allegations contained in it, and then that led me to the probable cause affidavit of the other defendants, the mom and the boyfriend and the grandma, and it's some of the most horrific details that you could ever imagine. It's one of those cases when you're a defense lawyer and the general public asks you all the time, how do you defend these people? And you always have your pat answers, you know, I'm defending the Constitution and whatever, but then you get this type of case, and I don't know that I could represent this woman if the allegations are true. I would, because I'm a defense lawyer, but boy, would it be tough.
That's saying something, because let's talk about that. According to this probable cause affidavit for McClure's arrest on April 9th, 2024, Officer Ryan Wright responded to a death investigation at this trailer park and saw paramedics performing CPR on Kinsleigh inside the home. The affidavit says, quote, Officer Wright advised that Kinsleigh's mother, Toni McClure, 29 years old, stated she had just picked up Kinsleigh after she spent the last 1.5 months with her father, B.W. Officer Wright advised Toni, stated Kinsleigh had a headache and that her legs had been trembling. Toni stated that when they arrived home, Kinsleigh collapsed onto the floor. Officer Wright stated Toni called for emergency services after approximately 20-30 minutes. Officer Wright observed a bruise on Kinsleigh's face and noted that it appeared Kinsleigh was malnourished. So the paramedics rushed this little girl to the hospital, but doctors confirmed she was dead. The damage to this child's body that was noted by hospital personnel is heartbreaking. Quote, "It appeared Kinsleigh was severely malnourished. Kinsleigh was thin and her eyes were sunken. Kinsleigh had what appeared to be fecal matter on various parts of her body, including the bottom of her feet and in her hair. The fecal matter had matted to her hair and to the bottom of her feet. Kinsleigh had what appeared to be lice or other similar type tiny insects crawling on her face and in her hair. Kinsleigh's hair was very short in length and appeared very thin. There were also what appeared to be bites or other unknown sores on Kinsleigh's abdomen area. The 5-year-old had reportedly weighed just 21 pounds when she died." Andrew, there's one thing about testimony, there's one thing, this story versus this story, but how critical is information provided by medical professionals, doctors, first responders, when you're trying to understand what happened to a small child like this?
It can be very, very important, and usually is the most important thing outside of confessions and so forth, which kind of exist in this case. But it is to paint the picture at trial of what this child went through, having a doctor in his suit come up and swear under oath he's going to tell the truth, and then details with photographs pointing to the different pieces of fecal matter or whatever, the bugs and the lice. I mean, the jury will not be able to tolerate that. I'm just telling you, you'd like to think you can win a case, but this might be one that is unwinnable.
Well, let me ask you that. If evidence is presented of photos of injuries or testimony from expert witnesses, is that enough when you're dealing with a vulnerable victim like this? When you're dealing with someone this young, not an adult, right? The alternative explanations, I think, become limited. If you present photos of those injuries and testimony, what is the defense? I mean, is there anything more prosecutors need to present? Do defense attorneys present their own medical experts to say there's alternative explanations for how these injuries happen? Because if you're talking about lice and you're talking about fecal matter, the caregivers are responsible, no?
Yeah, and the emaciated body as well. And she weighed 20-some pounds at age 5. Yeah, the only defense you're going to have is the pointing the finger at somebody else defense. And the mom, Toni, tried to do that initially by pointing the finger at a dad that in the end you find out she had just flat out lied to the police. She pointed the finger and said, "This child, Kinsleigh, has been with the dad for the last number of months. I had no knowledge of what was going on at his house." Then you find out that she just flat out lied. So if you are a defense lawyer and you do not have the ability to point the finger at anybody else and you get the medical evidence, it's one of those cases where you really just need to sit down with your client and have a come to Jesus talk about the right moral thing to do.
Let's talk about that, because when a detective did an interview with McClure at the hospital, she said that Kinsleigh is one of the children that she has with her ex, BW, who we now know is Bradley Welty. Now, McClure also had a child who was just a few months old with her boyfriend at the time, Ryan Smith. McClure told officers that Welty had wanted Kinsleigh to come stay with him, so she agreed and met up with him at a McDonald's. And according to McClure, she spoke with Kinsleigh while she was away, but it was only through audio calls. Bradley reportedly called her after several weeks to say he had a work commitment out of town, couldn't watch Kinsleigh anymore, so they met back up at the same McDonald's. This is according to McClure. And that is reportedly when she realized what a bad state Kinsleigh was in. But get this, another detective was at the trailer where McClure and Smith had been living with the kids, and McClure's mother, so Tammy Halsey, her grandmother, and her great aunt, they showed up. And it turns out they were told a much different story. What they heard, according to the affidavit, was that Kinsleigh had fallen in the bathtub when McClure had momentarily walked away. When McClure came back, Kinsleigh was reportedly underwater and had drowned. So Tammy claimed that McClure tried to do CPR, but it was unsuccessful. And the women also told the detective that Bradley Welty was not involved. The affidavit states, Tammy stated Kinsleigh's father, BW, was not involved and had not been involved with Kinsleigh for some time. Tammy stated BW had not had contact with any of the children because he was in and out of rehab. Tammy stated BW would not even know what the children would look like, and she did not know where BW was located. Tammy also stated the children had been staying with Toni's boyfriend, Ryan, for some time. So according to the police, all the people involved in this situation couldn't seem to keep their stories straight. McClure said Kinsleigh had been with her biological father for weeks. Kinsleigh's mother, Tammy, told police that would never have happened. McClure reportedly told a DCS caseworker, who just so happened to visit the morning of Kinsleigh's death, that the little girl was with her grandparents. And when police got in touch with McClure's boyfriend, who had the other children, he said the kids had been with him for several days and then admitted that that was a lie that Tammy told him to tell. So it's a complete mess here, Andrew. And how does that affect everything when you're having these multiple stories?
Well, I mean, if you're a prosecutor, it just makes things so much easier that you can point to the fact that lying shows intentionality. The lead count on the mom is murder, and you need intentionality there. And when you are lying, you know that you have done something wrong. And I think that, the mom telling the boyfriend to tell one lie. Now, the grandma, her name is Tammy Halsey. That's the grandmother of the deceased child. I don't know if she's scurrying at that point or she just didn't know which lie to tell, but she basically told the police, yeah, my daughter lied to you. I don't know if she used those words, but everybody's starting to scatter now, it looks like. And probably what's going on is, what's really interesting to me is ultimately the mom who's charged with murder, she basically confesses. Had she not done that and just remained quiet, the other two that are now charged with F1 and in Indiana, that's 20 to 40 years. That's the boyfriend, Ryan Smith, and the grandma who are charged with neglect causing death. If the mom would have shut up and not said anything, they would be more valuable, they being the boyfriend and the grandma. But I don't think the prosecutors even need them anymore. The mom has confessed basically and said, I did wrong. And now they're all going to, boil together, I think, in this case.
Yeah, that's a really good point, because there are other aspects to this, right? We talked about physical evidence. What does the physical evidence show? So while all this is going on, you had crime scene technicians that were going over this trailer with a fine-tooth comb. In the back bedroom, they saw bunk beds where it appeared two children had been sleeping or slept. There was a large dresser in front of the closet in that room. And when they moved it out of the way to open the door, the sights, the smells, horrific. The carpeted closet was full of human waste. A horrific part of this affidavit reads, there had been what appeared to be small handprints on the interior of the closet door. These handprints appeared to be marked with fecal matter. So when McClure spoke with detectives about that closet, she claimed to them that one of her sons had a seizure disorder, and when his seizures occurred, he would use the bathroom in the closet. But in fact, investigators believe that Kinsleigh was kept in there almost constantly for around 5 months. The day after Kinsleigh died, McClure went with detectives to the police station for an interview where they say that she waived her Miranda rights. And detectives wrote, quote, eventually, Toni admitted that she had lied to detectives about the version of events with BW. Toni stated BW was not involved in any manner and that he had not been involved with the children for over 1 year. Toni stated BW likely had no knowledge that Kinsleigh had even died. The affidavit goes into a lot of detail about what McClure had to say during that interview, but I want to highlight some of the most maybe shocking things revealed during this conversation, like, quote, Toni stated she and Kinsleigh did not share a connection or bond. Toni stated she was not going to lie. Kinsleigh told her that she wanted to die just prior to her death. And this one is particularly chilling. Toni explained that she never looked at Kinsleigh close enough to see the bugs on Kinsleigh. Now, according to police, McClure kept Kinsleigh locked in that closet almost all the time. She said Kinsleigh would talk to herself in there and often yelled out that she was hungry or thirsty. McClure even said during her interview that saying she was hungry or thirsty was Kinsleigh's slogan. McClure also made it clear in her interview with detectives that she didn't want Kinsleigh around anymore. Quote, Toni admitted she had given up on Kinsleigh. Toni repeated that she had failed Kinsleigh. Toni stated she knew that everything she had done to Kinsleigh was wrong. McClure also threw her own mother under the bus. The affidavit states, Toni felt that Tammy shared some of the responsibility for what happened to Kinsleigh because she knew everything, but she never helped or did anything. You know, Andrew, aside from just the human aspect of this and how horrific it is for me to read it, from a legal point of view, after saying all this, after her, Miranda rights were waived, it's like she's checking every one of the elements for the charges here, right? In order what prosecutors need to prove.
Yeah, exactly. When you were reading that, that's exactly what I was doing. I was thinking, well, they got that. And then murder's hard to prove intent sometimes. But when she says, I didn't want her around, well, that's all the jury needs, because even if a jury thinks, I don't know if they proved intent, I want her found guilty of murder. That's the task of the defense lawyer, is to somehow get the jury to really focus on the constitutional principle of proof beyond a reasonable doubt. And intent can be very hard to be proven. She was feeding her. It just wasn't a lot. She was giving her water, but it wasn't as regular. I mean, these are the things that you're left with as a defense lawyer, and it really sucks, frankly, to be in that position. But sometimes you'll get one juror, just one, that'll say, I don't don't know if we proved intent, or maybe more than one, but they really want to find guilt. Well, then you get that little nugget there of, I didn't even want her around anymore. And then, hey, that's enough for me as a jury, guilty of murder. I mean, I think this is going to be a very, very tall task for whoever is handling the defense.
It's very, very, very difficult to say that after a criminal defendant allegedly admits to these things, after being read her Miranda rights or after waiving Miranda rights, that interview should be thrown out. I mean, what would they have to show? That she completely didn't know what she was doing, or that detectives manipulated her in some way? I mean, that feels like a tall task, right?
It's yeah. The only thing that they could really hope for is in Indiana, when you are in a police station, it is required under the rules to videotape that or audio tape it, and you hope that maybe the video or audio tape just didn't happen because the police weren't thinking very clearly or something, because they were so outraged about what they saw. But short of that, this is something we in our office are challenging all the time, trying to figure out how can we toss out this confession. And I'd say like 1 out of maybe 100 times, 2 out of 100, something like that, you're successful. The other times, they're going to find a reason, the judge will, or in the Court of Appeals, to keep that confession intact.
Now, police say Ryan Smith agreed to come in on the same day that they interviewed McClure, and he also waived his rights and spoke with detectives. Quote, Ryan stated, Toni decided it would be best to put Kinsleigh into the closet because it was safer for everyone else. Ryan stated she started to put Kinsleigh into the closet around Thanksgiving of 2023. Ryan stated that in the last 3 to 4 months, he had only observed Kinsleigh out of the closet about 10 times. Ryan stated he did not seek any medical attention for Kinsleigh because of his love for Toni. Now, both McClure and Smith, they were arrested that day, April 10th, 2024. Investigators interviewed Kinsleigh's 2 brothers, one who was 4, another who was 6. They used various words to describe the closet that Kinsleigh was kept in, including timeout, the cage, the corner. The 4-year-old told police Ryan was mad and he smacked Kinsleigh when she was on timeout in the cage. Bruises around her right eye and cheekbone were noted during Kinsleigh's autopsy. The 6-year-old, identified in the affidavit as BW, said when she was in the closet, Kinsleigh was given 1 sandwich a day. Quote, BW stated Kinsleigh would ask their mother for a drink, but his mother never got her a drink. BW explained his mother did not go to Kinsleigh when she asked for her, and if she did, she would tell Kinsleigh no when she asked for a drink. BW also said that Kinsleigh had to stay in the closet and wasn't allowed to have food or toys because she was, quote, bad. Now, the affidavit also indicates that Kinsleigh's grandmother, who we've been talking about, Tammy Halsey, knew about what was going on and allegedly contributed to that abuse. After Kinsleigh died, DCS got a report from the director of food services at a local school district. She said that Halsey had been a food services manager in an elementary school and had talked to employees there about her granddaughter. According to an employee who did an interview with police, quote, Tammy said that while Kinsleigh was staying the night at her home, in order for Tammy to sleep, she had to tie the child to the bed. She did this because Kinsleigh would not stay in bed as she wanted to get up to eat and drink. I mean, if these allegations are true, can you blame her? Halsey later admitted to officers, according to the affidavit, that she used duct tape to try to keep Kinsleigh in bed, but that the little girl kept getting out of it, so she finally gave up. Halsey also allegedly talked about a time that they had all gone to a party at a family member's home. This was just days before Kinsleigh died. Quote, Tammy stated as soon as Toni arrived, she immediately told Kinsleigh to go to the corner because she was in trouble. Tammy stated Kinsleigh had to stand up and remain faced directly into the corner. Tammy stated Kinsleigh remained like that for as long as she was at the party. Now, the next day was the solar eclipse, and Halsey stated everyone came to her house to watch it, but that Kinsleigh was forced to stand in the corner for hours again. And just days later, Kinsleigh would be dead. In their interviews with law enforcement, all 3 defendants, as well as others who had interactions with the family, like Smith's mom and cousin and Kinsleigh's aunt, they apparently said that they knew something was wrong, but didn't report it to anyone. So what charges do the 3 defendants now face? Well, McClure is charged with murder, criminal confinement resulting in serious bodily injury, and battery on a person less than 14 years old. The trial is scheduled for early next year. Smith is charged with 3 counts of neglect of a dependent resulting in death, as well as criminal confinement resulting in serious bodily injury. He is currently scheduled to go on trial in December. And Halsey is charged with 2 counts of neglect of a dependent resulting in death, 2 counts of neglect of a dependent resulting in serious bodily injury, 1 count of neglect of a dependent resulting in bodily injury, and 1 count of failure to report. Her jury trial is also scheduled for next month. Andrew, by the way, why not charge all of them as co-defendants as part of one case?
Yeah, that's a great question. I wondered that myself. I don't know the answer to that question. The Marion County Prosecutor's Office, which is Indianapolis, sometimes they will put all the co-defendants together and sometimes they won't. That doesn't mean that they can't gather those defendants all together still in one case at trial. That could happen. They could still try to join all those parties together. But I don't know if there's a strategy involved there. It doesn't make sense to me. It seems like they would all be better served in more judicial economy if you just had them all together at trial and try one case instead of three.
So obviously, this is truly a horrific case, a horrific tragedy that, as we talk about many times, absolutely preventable, right? And to make matters worse, as the defendants get closer to trial, there are claims that the Indiana Department of Child Services, DCS, essentially ignored what was happening inside of that Indianapolis trailer. Why? Because Brian Welty, Kinsleigh's paternal grandfather, has filed a lawsuit in Marion County Superior Court on November 6th. And he is suing not only the defendants and DCS as a whole, he has also directly named 10 DCS employees who he claims knew or should have known that Kinsleigh was in grave danger. According to Welty, Kinsleigh was removed from her mother's care multiple times early in her life, sometimes staying with him, sometimes being placed in foster care, and his lawsuit reads, yet, as a result of repeated failings by the Indiana Department of Child Services and its employees, Kinsleigh was returned to her mother's custody multiple times, despite clear evidence that defendant McClure posed an ongoing risk to her safety. After returning Kinsleigh to her mother for the final time, DCS and its employees failed to investigate subsequent reports of abuse and neglect until Kinsleigh's death. Andrew, talk about this lawsuit. What sort of evidence would Welty need to provide to back up his claims? I mean, DCS reports, witness statements, messages between caseworkers, because it's not every day you see a lawsuit like this.
Yeah, I think you're on to something there with the messages between the caseworkers. I think the reports are important. I think statistics in this case, they've mentioned some statistics in the lawsuit about what the national requirement is, 5 to 6 children that you're taking care of. I think it was what the number was per DCS caseworker, but they have as many as 35, like 4, 5, 6 times as many children that they are watching. So I'd say getting into the minutia of what is going on at the DCS, how many people are they, do they have employed, and then how many children are they watching? That's going to be a part of it. And also, I do agree, communications between caseworkers, what are they saying? How are they trying to cover their butts? That usually comes back to haunt them in a lawsuit.
Back to the lawsuit, it lays out the reports and apparent lack of follow-up that allegedly precipitated Kinsleigh's death, naming each of the family case managers or DCS supervisors that were purportedly involved. According to the complaint, Kinsleigh and 2 of her siblings, they were brought to a hospital in August of 2021 for concerns about abuse and neglect. These children were reportedly covered in welts and bruises. They appeared to be underfed. They were removed from McClure's custody, but she got them back a few months later in December, according to the lawsuit. Welty claims this is because DCS failed to present a medical witness at a fact-finding hearing. November 6, 2023, the lawsuit claims that DCS got another report that Kinsleigh was being abused and neglected. Quote, the report alleged that defendant Toni McClure was not feeding Kinsleigh, left marks on Kinsleigh after hitting her with a belt, and forced Kinsleigh to stand facing a wall for hours. Despite this long-standing pattern of abuse, defendant Ayanna Jones closed the foregoing assessment as unsubstantiated only 2 days later, despite never having made face-to-face contact with Kinsleigh. And the grandfather claims that the report Jones filed had multiple factual errors in it, including misspellings of both Kinsleigh's name and her mother's. It also claimed that there was no information about the family's history, despite interactions with DCS that apparently went back years. And the lawsuit says defendant Rochelle Smith approved the expedited closure of that November report as unsubstantiated. The complaint continues. On December 5th, 2023, DCS received a second report that Kinsleigh was severely underweight, appeared malnourished, and that defendant McClure was not feeding Kinsleigh. The DCS caseworker was unable to locate the family. Defendant Casey Stegall closed this assessment as unsubstantiated on December 19th, 2023, despite never having made face-to-face contact with Kinsleigh. Defendant Ryan Peschke approved the expedited closure of this assessment as unsubstantiated. Days later, apparently another report came in about Kinsleigh appearing malnourished, and that report also said that the home didn't have heat or running water. The lawsuit claims that the DCS worker was, quote, unable to locate the family, and the assessment, as we've been talking about, was closed and declared unsubstantiated. 2 days after that report was closed, apparently a fourth came in, indicating that Kinsleigh wasn't allowed to eat and her hair was falling out. Quote, despite this pattern of grave allegations and mother's substantiated prior history of neglect, defendant Daria Jackson claims she was unable to locate the family, did no investigation, and closed this assessment as unsubstantiated on January 8, 2024, despite never having made face-to-face contact with Kinsleigh. Defendant Tammy Downs approved the expedited closure of this assessment as unsubstantiated. January 11th, 2024. That marked the fifth report about Kinsleigh, according to this lawsuit, with the person saying that the little girl was treated differently than McClure's other children. That report also alleged that Smith and Halsey knew about or participated in the alleged abuse. The lawsuit says, quote, defendant Crevelin Ibarra did no investigation, made zero effort to force defendant McClure to allow personal observation of Kinsleigh, and closed the assessment as unsubstantiated on January 24th, 2024, despite never having made face-to-face contact with Kinsleigh. Defendant Ashley Coffer approved the expedited closure of this assessment as unsubstantiated. Quote, upon information and belief, approximately 1 month before Kinsleigh's death, DCS employees saw Kinsleigh in the home and took photographs of her, but did not act to remove her from the defendant McClure's care, despite her emaciated appearance. And this lawsuit also addresses the workload of Indiana DCS. According to the suit, the Child Welfare League of America recommends between 12 and 15 children per caseworker, but Indiana's current caseload, that far exceeds that, according to the lawsuit. The lawsuit states, quote, DCS caseworkers report having caseloads as high as 35 individual cases for years at a time. Upon information and belief, one method DCS has employed to reduce caseload burdens is the implementation of internal policy directing caseworkers to refer 50% of their cases to the Safe Assessment Closure Team for expedited closure. But instead of fast-tracking low-priority cases as intended, DCS is using SAFE Act to quickly reduce caseload numbers despite serious safety concerns. 3 reports of Kinsleigh's abuse were closed in an expedited fashion pursuant to DCS's SAFE Act policy. So this lawsuit lists 6 legal claims here against the DCS and its caseworkers. Welty claims negligence as well as a survival claim. He also claims that the DCS defendants deprived Kinsleigh of her civil rights. And against the 3 defendants, Toni McClure, Ryan Smith, Tammy Halsey, he claims negligence and intentional infliction of emotional distress. Count 5 is a claim of battery allegedly committed by Kinsleigh's mother, Toni McClure. Welty is demanding a jury trial to determine damages that Kinsleigh's estate should receive. And during a news conference announcing the lawsuit, according to reporting from WIBC, Brian Welty said, when they told me she was gone, I felt like my soul left my body. No child should ever die that way. No one should ever have to bury a 5-year-old because people didn't do their jobs. DCS keeps talking about reunification, about getting kids back with their parents. That's fine when the parents are safe, but when they're not, that policy kills kids. It killed my granddaughter. And WIBC reported that a DCCS spokesperson declined to comment on the lawsuit, but said that the agency takes child safety very seriously and fully cooperates with criminal investigations. Andrew, what is your reaction to these claims? I mean, what stands out to you when you look at these causes of action?
I think what stands out is just the legal phraseology that I think is important in this case is deliberate indifference. That is the phrase that the plaintiff, the grandfather, is going to have to prove that the DCS acted deliberately indifferently. And that's just one of those words and phrases that really we don't really know what it means necessarily. But some of the facts are, for example, they couldn't even get the girl's spelling of her name correctly, okay? And that may seem like a small thing, but that's just like, it's so bad this girl has died and now they can't even get the name straight. It seems as, at least the allegation is, that some of the caseworkers just flat out lied. They didn't go to see the child, but they said that they did. There's also a bad allegation that one of the caseworkers went and saw the little girl about 30 days before she died. She would obviously she's in this cage, this closet, she's emaciated, she's got feces all over her, and they just wrote off, hey, it's unsubstantiated. She's doing fine enough. We're done with that. We're going to move on. And they had this. The thing is, the grandfather that is suing, the grandfather, had a great relationship with this little girl. He had the care, custody, and control of that girl for 2 or 3 years and had developed a bond with her. And he was a great viable option. That girl would be alive. She would be alive had the DCS employees done their jobs, is the allegation, and if they are true, and simply had taken the little girl to her grandfather's house where there apparently was love and a good household. And all those things are going to, it's a compelling lawsuit. It is hard. I'm a criminal defense lawyer. I'm not a civil lawyer, but I know there's all types of defenses and things that, immunities and so forth. I don't know what they need to overcome those, but boy, this type of fact pattern could get you there.
You highlight a very, very important point here. Yeah, we could talk about the law. We can talk about innocent until proven guilty. We could talk about, yes, you have to prove liability here, and we can get into the law back and forth and all that. But the main underlying theme we talk about in a lot of these cases, particularly when we focus upon child protective services, DCF, things of that nature, was this preventable? Was there another option? Could someone else have taken care of the child if they were given that chance? I can't tell you how many stories I cover where family members say, I would have taken him, I would have taken her, I would have taken them. And that is just the absolute tragedy, because putting aside the criminal liability, civil liability, this shouldn't have happened. This child should still be alive. And I think that's a really important point that you highlight. Andrew Baldwin, thank you so much for taking the time. Really, really appreciate it. Thank you.
Thank you, Jesse.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.